Afternoon, everybody. Happy November 21, and thank you for joining us to discuss all the new things that you need to know about religious discrimination, harassment, and accommodation. Katie and I are excited to be here with you today to discuss these things. And as always, hop to the next slide. If you have any questions or anything, next slide, Raven, thanks. Drop them into the chat box or the Q&A, and either Katie or I will be monitoring them, and we'll do our best to answer as many as we can. So the thing that we're going to cover today, a section on what is actually a religion under Title VII. Then we're going to talk about religious accommodations in light of the new law in 2024 about the standard that applies. And Katie's going to run through some great examples. And then I'm going to cover religious discrimination and harassment. And so with that, we do have a poll that Raven is going to send around, and we want you to go ahead and answer those questions, and she'll pop up the results, and we'll just keep rolling because we have a lot to cover today, but thanks for being here. Next slide.
I'll go ahead and talk about religion under Title VII. Okay, so Title VII defines religion to include all aspects of religious observance, practice, as well as belief, and not just tenets of a faith. So it doesn't have to be something that is, on the church's abstract of faith or on the website or on the scrolls. Maybe it's a practice or belief that they maybe have developed based on their own sincerely held religious belief. And these religion encompasses non-traditional beliefs. So it can encompass things that someone believes that answers a higher question. It usually deals with things of the universe and morality, as long as it's sincere and meaningful, and then it occupies a place in the life of that person that's parallel to what maybe God might be to some people. So religious is very broad under Title VII. Next slide for me. And belief in God is not necessary. So it covers non-theistic beliefs. An atheist is covered as a religion under Title VII. So again, just anything that is parallel and personal to that person, that would what God would normally be to a person that believes in God. It's very broad. It does not include social, political, economic philosophies, personal preferences. I feel like this came up a lot a few years ago when the COVID vaccine mandates came out. A lot of employers were getting accommodations requests based on religion. And a lot of those kind of edged onto more of social, political, personal preferences. So these things are not covered as religion under Title VII. And again, religion answers an ultimate concern or ultimate question in life. So those big things about, why are we here, our place in the universe, right and wrong, morality, that's typically what a religion is. Next slide. So I will say, usually religion, whether someone has a religious belief or practice, is usually not a question that we have to answer a lot. And I think that is because courts and the EEOC really err on the side of finding that that person does have a religion that's protected under Title VII. And of course, that doesn't mean, that anything and everything goes, but they do err in favor of the employee that, yes, it does sound like that this is a belief that this person has that answers a big universal question that is parallel to almost God in their personal life. So the EEOC and courts really side on the employee side on that, which, is typically the case anyways. It doesn't have to be organized. It can be very uncommon. It can be a very small subset of people. They don't have to belong to a recognized religion or church. It can seem illogical or unreasonable, but again, Title VII is very broad when it comes to this. Okay, I think we can go to the next slide. So I think some of this, Chris, I think is this where you pick up?
Right, I forgot to come off mute. So, the religious protection under Title VII includes theology as well as moral, ethical beliefs. And Katie mentioned this, but it relates to the ultimate concerns, life, purpose, death, humanity's place in the universe, right and wrong, or part of moral and ethical belief system. She mentioned social, political, and economic philosophies or preferences are not protected. And the key here would be whether a practice is religious, depends on the employee's motivation. So somebody who, for example, this is a great example, dietary restrictions. Is it religious motivated? Is it ethically, morally motivated? Which is interesting because that might contemplate folks who have ethical consummation, consuming practices like vegans and such for the basis of ethics. And to Katie's point, the courts will resolve in favor of finding a religion. And so it's probably best not to challenge this. There are ways, if you look at the EOC guidance, there are ways to inquire, and there might be specific instances where you have to be sure that the practice that the employee is actually engaging in is on the basis the employee's motivation or their faith. But as a general rule, typically you wouldn't want to get involved in this aspect of the analysis for fear of being ending up on the wrong side of it with either the EOC or a court. Next slide. So here's some examples of religious beliefs. A Catholic employee wants a schedule change so they can attend church services. A Muslim employee requests an exception to the company's dress and grooming code to wear a headscarf. Hindu employee requesting an exception to allow her to wear her bindi, a religious forehead marking. Atheist asked to be excused from religious invocation offered at the beginning of staff meetings. Someone who's adherent to Native American spiritual beliefs seeking unpaid leave to attend a ritual ceremony. And employees who identify as Christians, but not affiliated with a particular sect or denomination, request accommodation for a religious belief about working on the Sabbath. These are just some examples to help explain what is and what is not a religious belief. I thought this would be interesting. This tells you the world religions. It's a world religions map. And I have in these resources the actual link to the map. And if you scroll over each area, each nation, it'll tell you the demographic, the religious demographic for each nation. It's very interesting. And so red stands for Buddhism, purple is Christianity, orange is Hinduism, yellow, indigenous, green, Islam, blue, Judaism, pink is non-religious, and turquoise is other. The reason I think that this is important to point out is if you see in the US, Christianity is clearly the most dominant religious group. Others are represented, and I'll get to that. But that is from a standpoint of a human resource professional's responsibility to understand that as this majority, we have to be particularly sensitive to minority beliefs. Next slide. So this next slide is the breakdown in the US. These are the percentages. I was surprised to see 16.4% is non-religious. That was I was surprised to see that was the next stat after Christianity. And then you see the rest: Judaism 1.8. 1.2 Buddhism, 0.9 Islam, 0.6 Hinduism, 0.6 other, and 2.2 indigenous. These statistics were taken from a 2010 Pew Center research study. So those may have changed by now. This is the most current data on that world religion map. So we did get the results in from the poll, and Raven's going to pop those up, and we'll take a brief look at that. So how comfortable are you to feel discussing religious topics at work? 55% was the majority said somewhat comfortable. 18% said very comfortable, 18% said not comfortable, and 9% I avoid it. That all makes sense. Does your workplace celebrate all or acknowledge all religious holidays. 35% said yes, all major holidays. So that's great. And I'm curious, religious holidays, according to all religions or just Christianity or one particular religion. And then 52% said yes, but only some. How important is it for your workplace to promote religious inclusivity? 61% said very important, 30% somewhat important, 9% not important. And I will tell you, Mike Unger and I, 2 Decembers ago, did a webinar on, being able to show up at work whole with your religion. And so this very important percentage suggests to me that many of us feel that way. Have you received training on or handling religious diversity in the workplace? 36% said yes, which I think is great. And then 64% no, which I think is probably more common. I'm surprised by how many you have. So thank you for doing the poll and participating. We appreciate it. And we'll pop on.
Okay, so I'm going to talk about religious accommodations. So Title VII requires employers to provide religious accommodations absent undue hardship. And so very similar to the ADA, it's a similar standard. There are some differences between the two, and we're going to talk about some of those today. So Title VII, religion is listed as a protected class under Title VII. And those religious beliefs that employers have to accommodate have to be sincerely held by the employee. So we're going to talk about that some today. And of course, absent undue hardship. Okay, so I'm going to go through a couple of scenarios. So a company has instituted a policy that employees cannot have visible tattoos showing while working. 2 employees ask for an accommodation based on their religion. So we're going to take a look at these 2 employees. So employee number 1, Edward practices the Kemetic religion based on ancient Egyptian faith. He states that he believes in various deities and follows the faith's guiding principle regarding truth and order that represent physical and moral balance in the universe. During a religious ceremony, he received small tattoos encircling his wrist, which express his servitude to Ra, the Egyptian god of the sun. When his employer asks him to cover his tattoos, he explains that it is a sin to cover them intentionally because doing so would signify a rejection of Ra. Okay, so you get this accommodation request in. Okay, let's go to employee number 2. Okay, Sylvia. Sylvia refuses to cover a tattoo on her arm that is the logo of her favorite band. She tells her manager that she feels so passionately about the importance of the band to her life that it is essentially a religion to her. So I know Chris and I talked about, usually you are not having to necessarily recognize whether that person actually has a religion, but, these are actually examples from the EEOC guidance. And going back to when we covered what is a religion, Edward had a accommodation request based on a belief that answered kind of these higher questions in life. And Sylvia just has a band that she really likes, and she's so passionate about it. She just basically says it's her religion. And, that's really not how religion is defined under Title VII. And so in this scenario, we would say that, Sylvia, sorry, we're not going to grant this accommodation request based on religious accommodation because you don't actually have a religion. Or you loving your band is not a religion. And so again, this isn't something that you're always going to have to weigh in on because I think courts just lean in favor of the employee. But, Title VII does give you room to make this analysis, and the EEOC guidance makes this clear. Okay, so sincerely held. So the religious belief or practice has to be sincerely held by the individual. And this is largely a matter of credibility. And again, I do feel like we saw this a lot when we were getting a lot of religious accommodation requests with the COVID, the vaccine mandates. And this question came up a lot. Is what this person is saying, is this a sincerely held religious belief that they can't have a vaccine. And so the EEOC guidance does give some factors to determine credibility, whether an employer really believes that that's a sincerely held belief. So it says, if that employee has acted inconsistently in the past with that professed belief, that can undermine their credibility. And you do have to be careful with that because employees can change their beliefs. They can develop new beliefs. And so they could have done stuff in the past and then decided, I'm gonna do this from now on or not do this. So it's a little bit of a gray area, but that does kind of undercut their credibility. Whether the accommodation is a desirable benefit for secular reasons. Maybe they're just making this religious accommodation request so they can get this benefit, and it has nothing actually to do with the religion. Whether the timing is suspicious, and really just any other reason that would cause that employer to question whether this person is really just trying to, give them the runaround a little bit or use this as an excuse. And again, I will say that this could trip up employers just because, again, courts and the EOC really side with employers on this. But I do remember a case one time when I think we were helping a client, Chris, with the COVID vaccine mandates, and they had sent in an accommodation request, an employee, and at the bottom of their request, it basically had this URL code like, how do I get my employer not to let me do the vaccine mandate or something like that? It was like very clearly they had pulled it off the internet. So, stuff like that can really undermine someone's credibility that they have this sincerely held religious belief. So that's just one area I remember it popping up.
Katie, that's good. That's a good memory. Of course, remember too, the standard was different then. It was more than de minimis, right? And so
Right.
now it's up. Katie, also we had this other matter where there was the employee who took off. She had already taken off for a weekend, and her cohort who worked at the machine with her decided he would say he had to go, or he asked for an accommodation, that he would have to go to a convention, a religious convention that was just a convention, but not a I think this is right, not a actual service or anything, just a convention. And he was saying his reason for it was she's not going to be here and I don't want to have to do all the work. And
Yeah.
so that was a situation where I think it would have been a gray area for an employer, and an employer might have been able to say, your reason was you don't want to be here and handle the work if she's not here. So, and then what you're going to talk about is undue hardship too, which I thought factored into that decision. But it's not that you have to do it every time. You just have to be super duper careful.
Yeah, that's right. Okay, next slide. Okay, so notice, this is very similar to the ADA. So the employer has to be put on notice. The employee has to put the employer on notice that an accommodation is needed. And they don't have to give any magic words. That's what the case law says. So they don't have to say, I need a reasonable accommodation based on my sincerely held religious belief or something like that. They don't have to use those buzzwords. It might come in the form of, I need time off to attend this church service. That is them requesting an accommodation. And there is this kind of third prong, and this exists under the ADA as well. It's that even if the employee doesn't necessarily make the request, but the employer knows enough to know that a policy is interfering with a religious practice, the EEOC guidance says that is enough to charge notice to the employer. And I do feel like that happens a little more rarely. It does come up in the ADA context for sure, but it's also under religious accommodations as well.
Katie, do you mean that the employer should on their own identify a situation where this is interfering with the employee's religious practice and discuss it with the employee?
So that is what the EEOC guidance says. I will say that. And, I tried to think a little bit about what context this would come in with the religious accommodations. On the ADA, it's a little more clear. Like if you are physically seeing someone that they can't do the job, then potentially based on a disability, that's enough to charge the employer with notice. In the religious context, I feel like most of the time it's going to come up as the employee is putting in a request. But I just want to put that out there that this is in the guidance that if the employer knows enough, you know, policy's interfering, yes, then you need to have a conversation with that employee and go through that accommodation process. And I guess I did just think of an example. I mean, if you are hiring, say, a Muslim employee,
Right.
you know that they wear a head covering. You maybe know that your policy has a dress code that says no hats or something like that. You know, you're probably put on notice enough at that point to have that conversation with that employee and provide that accommodation absent undue hardship. Okay, next slide. Okay, so Title VII for religious accommodations doesn't technically require an interactive process like the ADA, but you should still be doing that interactive process similar to the ADA. And that reason is because if you don't go through that conversation, and again, interactive process is just you having a conversation with the employee about what they need, about what accommodation the company can provide. If you don't have that conversation, it's going to be very hard for you to show undue hardship. And a lot of courts have even said, you know, this employer didn't have any kind of communication or discuss the issue with the employee, and now they're saying, you know, undue hardship. And so a lot of courts have said, no, you don't meet your burden of proof if you're not actually having that conversation with the employee. So while it's not like a technical requirement like it is under the ADA, you do still need to be having that conversation with the employee. Employers can request more information if it's reasonable. And the employee should provide this. So if the employee puts in a request and says, I need more time off to attend religious services, you know, the employer can say, well, how much time off, or when are the religious services? Or, you know, you can ask more questions to try to narrow in to be able to provide that accommodation or to be able to determine whether it's going to be an undue hardship. What you don't want to do is just make them give you a bunch of information on their religion that isn't necessary for that undue hardship analysis. So it's got to be reasonable there. Okay, and the employer doesn't have to provide the specific accommodation that the employee requests, and that's the same under the ADA too. You can provide an alternative accommodation if it fixes the issue. Okay, so I've got a little bit of a scenario here. So Jim agreed to take his employer's drug test, but was terminated because he refused to sign the accompanying consent form. After his termination, Jim filed a charge alleging that the employer failed to accommodate his religious objection to swearing an oath. Until it received notice of the charge, the employer did not know that Jim's refusal to sign the form was based on his religious beliefs. So what do we think? Do we think Jim's employer violated Title VII here? Well, the answer is no, right? The employer did not put, or the employee, Jim, did not put his employer on notice that the reason he wasn't signing that form was based on a religious objection. And so if the employer didn't have notice until the charge was filed, then no, that's not a violation of Title VII. And in reality, I think this would play out more where there should be a conversation there, and then probably the employer would find out, oh, he's not signing because of this religious objection, and then you can go through that accommodation process. But no, the employer has to be put on notice. Okay, next slide. Okay, and I see
So
a question.
Katie,
Yeah.
I was gonna, yeah, you've got it. Gina has a
Okay.
question. Was the employer obligated to have a conversation with the employee as to why he was not signing beforehand?
So I will say these scenarios are taken straight from the EEOC guidance, but I say yes. I think that they should have had a conversation with Jim. And, you know, because if you got someone, this has come up a lot, I will say, with employers. It's come up in our practice where people, you know, we're attorneys, so we have a lot of affidavits and things like that that sometimes people won't sign because they won't swear to an oath. So yes, I think the employer needed to have had a conversation here, but I will say that the EOC guidance did use this as an example of notice. Employee still has to put that employer on notice. But practically, yes, I think the employer should have that conversation.
Katie, do you think that if the company has a policy for any accommodations, religious or otherwise, that it is the obligation of the employee to bring it to the employer? And will that remedy what the EOC is saying is it's our job to bring it up affirmatively?
I think it would help. I think
Mhm.
having that policy would help, but I will say that the EOC guidance, it mirrors the ADA, that it does have that requirement in there that if the employer has enough information that they're on notice that a religious accommodation is needed, you've got to interact with that employee to find that accommodation.
Now that's just
Very,
tough.
is very tough. And I don't think I mean, I've never actually had that part come up in my practice. I think much more typically you're going to have an employee requesting that accommodation. But that is there in the ESC guidance.
Right. And then this is making an employer have to suggest something on the basis of somebody's religion and it not going well and them contending they're being harassed on the basis of the religion. It's just a tough thing to
Yeah,
think
and that's
about.
why I think, something like the head covering, I think that's probably a more clear-cut
Yeah.
example. But beyond that, it's tough to think of a situation where maybe that would apply.
Someone did say, and I had actually thought about this too, an anonymous attendee said, maybe a good example would be scheduling a meeting for a time when you already know an employee needs a break for prayer. I mean, that makes sense to me. In
Yes.
fact, I could think that would be at a minimum microaggression and consider.
Yes.
So yeah,
Yes, I agree. Okay. Second scenario, Diane requests that her employer schedule her for fewer hours so that she can attend church more frequently. Those are in quotes, so that's exactly what she asked for. The employer denies the request because it is not clear what schedule Diane is requesting or whether the change is sought due to a religious belief or practice. Did the employer violate Title VII? Yes, I would say so. They needed to have gone back to Diane and said, Diane, we understand you're asking for this, but how about you give us some more information on, when you need off? How often do you have church services? Your hours, things like that. They needed to have asked her for more information so that they could actually determine whether they could accommodate her. Again, you don't necessarily have to do the interactive process, but a court would look at this and say they did not do enough to determine that that accommodation was going to be undue hardship. Okay, next. Okay, what is a reasonable accommodation? I'm going to kind of speed up a little bit so Chris has enough at the end to do discrimination and harassment too. Okay, so what is an accommodation? What's reasonable? It's an accommodation is not reasonable if it only lessens the issue but doesn't eliminate the conflict. So if an employee is asking for a certain accommodation and you say, we don't have to give you what you're asking for, we're going to give you this other accommodation, but it's not actually getting rid of the conflict, that is not reasonable under the EOC guidance. The caveat to that is if you go through, you look at the employee's request for an accommodation and you determine that doing that would cause undue hardship, but doing it maybe only half the time wouldn't, you have to accommodate them up to the extent you can. And an example of that would be if an employee is asking for every Sunday off so they can go to church, and you say, okay, y'all go through the undue hardship analysis and determine that would be an undue hardship, but we could allow her off once a month or every other week, or get her to switch shifts every other week with someone. Well, if that's the case, you at least have to provide that kind of partial accommodation up to that point. Accommodations are not reasonable if they cut the person's pay or benefits or make them move to a new position if some other accommodation exists that wouldn't require them to do that. So you can't force them to take an accommodation that harms them if there's something else reasonable that the employer can do. And again, this is a very case-by-case basis determination. It's going to be very fact specific based on that employee and what they're requesting. Next slide. Okay, another scenario. Rachel, who worked as a ticket agent at a sports arena, asked not to be scheduled for any Friday night or Saturday shifts to permit her to observe the Jewish Sabbath from sunset on Friday through sunset on Saturday. The arena denied the request, but instead gave Rachel this time off only every other week. So they get in this accommodation request and they turn it around. They deny the request, but they give her basically partial time off. Did they violate Title VII? Well, they did if they didn't first go through that analysis of whether her initial request was actually an undue hardship. They can't just turn around and offer a different accommodation without going through that analysis. So if they got her accommodation request in, they actually determine it's undue hardship, then okay, they can go back with her, have that conversation, and offer her this other kind of partial accommodation. But if they're not establishing undue hardship, then this would be a violation of Title VII, because what they offered her lessens the conflict but doesn't eliminate it. Okay, so let's talk about the undue hardship standard. Chris mentioned that this changed recently. It did. Under the old standard, an employer could show undue hardship if it caused more than a de minimis cost to the employer to accommodate that person. And de minimis cost was a very, very low bar. Y'all probably know meeting undue hardship under the ADA is a very high bar. It's difficult, especially for large employers to do. Under the religious accommodation side, with this standard de minimis, it was very easy to overcome. It was like bottom of the barrel, very easy to show undue hardship. But we have a new standard, a new Supreme Court case from 2023 revisited this standard, and the court said, no, that was not the intent by de minimis with that old standard. We have a new standard, and that is, does it cause substantial increased cost to the employer in relation to the conduct of its particular business? So the court came back and said, no, we're bumping the standard a little bit higher. You have to show that it causes substantial increased cost. And they said the factors to determine that is what is the accommodation, and then what is the nature, size, and operating cost of an employer. And those factors are very similar to the undue hardship factors under the ADA too. And I'll just say again, we're always telling people this under the ADA, large employers that have you know, a lot of resources, it's going to be hard to show undue hardship. It just is, because you have a lot of resources, you have a lot of employees, people can fill in, whatever it may be. Not impossible, but it's harder to show. So this is the new standard, and go to the next slide for me. And I kind of put it in, you know, showed it against the ADA. So we have the old standard, the more than a de minimis cost at the bottom, which we're not using anymore. Then you've got at the top, you've got that ADA standard, which is you have to show significant difficulty or expense. And the court here basically said, we're going to kind of split the baby here and go right, you know, somewhere in the middle, basically. So that's where that current accommodation standard is. You've got to be able to show substantial increased cost. And the court specifically said, we're not raising it to the level of the ADA. We don't feel like that's necessary. So it's somewhere in the middle there.
So Katie, Gina has a question. Would an employer need to show a financial breakdown to support increased cost?
So I think that, yeah, that would be helpful. I mean, if you ever have to litigate that or have to respond to EEOC complaint, yes, I think hard numbers showing that cost is what you're going to need. I don't know. What are your thoughts on that, Chris?
I think more proof is better proof, as long as that proof, you know, so the question I would have is if we show a financial breakdown to support the increased cost, yeah, they'll, you know, any sort of administrative agency is going to analyze that in regards to any other increased cost areas and what we thought about those, whether we made the decision, you know, it wouldn't just stop with this. I think it's great to have that, but I think you have to be mindful that any federal agency can mine other information to see if this is a consistent position and if it's a genuine reason.
Yeah. Yeah, and we always tell employers, we deal with this probably more on the ADA side. You got to have some facts. You got to be able to articulate why this is undue hardship. People just want to call us and be like, oh, we're not doing the accommodation, it's undue hardship. And we have to say, well, is it really? Because let's talk about this fast. Because if we ever have to defend that, we are going to have to be able to do that. So, okay, next slide. Okay, I think I've just got a couple quick scenarios. All right. So David wears long hair pursuant to his Native
Katie,
American.
take your time.
Yes. Okay. All right. David wears long hair pursuant to his Native American religious beliefs. David applies for a job as a server at a restaurant that requires its male employees to wear their hair short and neat in order to provide a certain image to customers. When the restaurant manager informs David that if offered the position, he will have to cut his hair, David explains that he keeps his hair long based on his religious beliefs, but he offers to wear it up with a clip or under a hairnet. The manager refuses this accommodation and denies David the position based on his long hair. Is this a violation of Title VII? Should he been given the accommodation? And I would say, yes, he should have been accommodated. It's going to be very hard for this manager to show undue hardship here. The whole point is having a good image to customers. It's also, if you work in a restaurant, having your hair up so hair's not falling in the food, those things. David has requested what seems to be a very reasonable accommodation. I'll wear my hair up. I'll wear it under a hairnet. That's going to have the same effect of someone having short hair. So yes, I would say that it's going to be very hard for this employer to show undue hardship. I don't think that is going to be met here. All right, next slide. Okay, one last one. All right, Patricia alleges she was terminated from her job as a steel mill laborer because of her religion, Pentecostal, after she notified her supervisor that her faith prohibits her from wearing pants, as required by the mill's dress code, and requested as an accommodation to be permitted to wear a skirt. Management contends that the dress code is essential to the safe and efficient operation of the mill and has evidence that it was imposed following several accidents in which skirts worn by employees were caught in the same type of mill machinery that Patricia operates. The employer denies the accommodation based on undue hardship. Did the employer violate Title VII? So I would say no. I mean, they have a legitimate reason. They have some documentation that backs it up. They have a history of accidents involving skirts at the mill, and safety is a legitimate business reason. And so, I think going back to that good documentation, being able to articulate reasons and facts, this employer would have that here. And safety, for religious accommodations and for the ADA too, is a reason that you can stand on to deny an accommodation. Okay, I'll kick it over to you, Chris.
All right, that was excellent. Those examples were excellent. And we felt like we should cover those first since that was a departure and a change in how those cases or those requests would be analyzed. But let's go ahead and pop in and now talk some about religious discrimination and harassment. So discrimination, and you all know this, the folks on this, particularly this webinar, treating applicants or employees differently because of their religious beliefs or lack thereof on any aspect. And I think it's important to say or lack thereof in any aspect of employment, because I know that a lot of employers have religious signatories, recruiters and that sort of thing. They have them at the end of their signature block, and they talk about it being a Christian workplace or another religion workplace. I had a client with that one time too. And so any sort of decision not to hire on lack of an aspect of employment is something to think about in that context. So some examples from the EEOC, again, what can an employer do? What can't an employer do? And just as Katie was covering examples, I'm gonna cover different aspects of things to sort of frame what is and is not discrimination, what is and is not harassment. So an employer cannot require an employee to attend prayer. That seems easy enough. Most folks would not do that. But how do we view if it's a mandatory luncheon that the employee has to go to and it is prayer based on a single religion? Is that forced attending prayer? An employer can't enforce an employee to abandon or alter their religious practice. The example was forbid an employee to pray on their break. I can think of an example where you have to pray 5 times a day and only permitting the employee 2 breaks a day. instead of the breaks that they need to exercise their prayer requirements on the basis of their religion. You wouldn't have to pay for all of the breaks outside of the ones you normally do, but to deny it, and we think about in terms of production and how that might impact production. Absent undue hardship, we couldn't deny it. This was another thing that I thought was important, and I think maybe does happen sometimes: religious segregation, which is in assigning an employee to a non-customer contact or a separate customer because of actual or feared customer preference. So, for example, someone, when there were a lot of things that were happening with 9/11, someone who is Muslim or Islam, thinking that they might interfere with your customer base. Next slide. So some lawful observances and practices based on one's sincerely held religious beliefs, observance of Sabbath or a religious holiday. Now, Katie covered accommodations. If you have a policy where everybody has to work their shifts and it's a 24/7 place, and no one gets a break, no one gets exceptions, there's no exceptions, then you can enforce that policy across the board for the same with everyone. I do think this change in the standard, though, now requires you to show undue hardship when you get an accommodation request, whereas before, I'm not sure it would have, if you had this policy in place that no one is allowed to, to have days off for their services. So that is important to keep up with. Need for prayer during during work hours, strict dietary requirements, practice related to dress or personal grooming. I think everybody remembers the EEOC versus Abercrombie and Fitch matter. They had a look policy, and there was an employee who wanted to wear a hijab, and they would not permit her to do so. Or I'm trying to remember exactly, I think she also got scored lower on her review because of her hijab. And so that was found to be a violation. Practice of not working while in a mourning period. And in this scenario, I'm thinking they probably mean, at least the one I know of, is the 7-day mourning period for people who practice Judaism. And again, unless it's an undue hardship, an employer has to permit it. And denial without undue hardship, which I think is an important thing to think about. It's not just that you're violating the ADA because you didn't grant an accommodation by showing you didn't have that there was undue hardship. You're also discriminating. You could be found to be discriminating against the employee on the basis of their religion. So that's important to think about. Next slide. Employers may not refuse an employee's request to wear a turban or other similar religious garb simply because it upsets coworkers, clients, or customers. Katie made a good point. There's going to always be exceptions for safety standpoints. And if you note, an example that I have there is, can we limit someone who has, for instance, Katie's example was the skirt. Mine is a hijab. And while working in a machine that might catch and pull the employee into the machine, causing injury. And of course, that's a bona fide safety reason to protect the employee. And you could deny the request, but one of the things you might consider before you do so is, can it be worn? You always have to look for the most narrow application of the policy and determine if there's a way to permit it in a modified way or in some way. Can it be worn in a way that doesn't fall below whatever is the permitted hair length for all the other employees? And then it is important to determine whether or not this is a genuine policy not intended for the purpose of subterfuge, by looking at what other long items or loose clothing or are there hair lengths, just sort of analyzing everything else that is required or not required for people who operate the machines, and determining whether or not this is a accommodation we need to request, even though we think it's a safety concern. But obviously, if we thought it was a safety concern, we would have other safety concern policies that would, even though neutral, would impact the employee who wishes to wear a hijab. Next slide. What about personal items? You get that request a lot, or I get that request a lot when I'm doing training. Can we have a Bible at work? Can we wear a cross? Can we wear a t-shirt with a religious display on it? Can we display religious icons, etc., artifacts in our office? So the first question is, what's the employer's policy? Do they permit employees to decorate their work areas, or do they prohibit it? And if they do allow it, then has anybody ever been required to scale it down or limit it in a certain way? And if it's been applied across the board, then you can apply it here too. But if they have no issue with personal items, then they should be allowed to have them. And you can obviously have exceptions. The exception in this example was the receptionist desk or the front desk. And then if an employer has an outright, you cannot display personal items in the workplace, then they cannot display religious items. But would that mean personal items would include pictures, is things, little things that people put on even their computer desk. So, you would have to verify, are we enforcing this policy, even though it's this policy? Do we have people who have family pictures and such? Well, then we probably need to let the person display their religious items. Next slide. There is an exemption, and it is for religious organizations and religious educational institutes, and they are exempt from the religious discrimination provisions only as it pertains to religion. Something I have come across is where I have a client who is a faith-based organization, but their services are not providing religious services or addressing a religion need, but instead they're in, commerce. They're cycling a product, and it's a product that's not religious based. It's just a general product. But because they said they're a faith-based organization, they believed that they were protected from application of these rules, and that they could hire people that had their same faith, and that they would not, have any trouble with religious harassment or any of the rules and the laws that Katie and I have been talking about here today, because they made it known from the outset, we are primarily, our company follows this religion. And so the only companies that get that exception are truly those who are like churches or education, church schools, or any sort of company that prepares and distributes religious products, for example, devotions and Bibles. Now, another interesting question is, do they also distribute other non-religious things? And so you would evaluate that as well. And then to determine whether or not, is this the religious purpose of this company? Is it religious? We can look at the articles of instruction or their day-to-day operations. There's also a ministerial exemption that Katie and I have been working with the client pretty in depth. And it does not apply to Title VII to anyone in the entity that is a clergy. And clergy is not just ordained clergy, but deacons and those who engage in aspects of worship that would be considered the religious aspects of the organization, as opposed to the administrative functions. Katie and I had a really hard time figuring out whether or not FMLA leave would or would not apply. And there are very few cases in the nation, and the EOC certainly doesn't speak to it. And in fact, the EOC specifically talks about Title VII. So it's an interesting question that we're not sure exactly how it would come down, because that shouldn't apply to anything on the basis of religion. But it could go either way. Next slide. Harassment. This is when employees are required to or coerced to abandon, alter, or adopt a religious practice as a condition of employment, which is the quid pro quo harassment that we all know about. Or they are subject to unwelcome statements or conduct that's based on religion, and so severe or pervasive that the individual being harassed reasonably finds the work environment to be hostile, abusive, and there is a basis for holding the employer liable. The new standard that the EOC came out with this year, I talked about it, I believe last month, it does require that the employee who was the victim of harassment actually feel harassed, perceive harassment. So again, here you see denial of an accommodation could be seen as harassment in some circumstances. So it's important to keep in mind that discrimination and harassment come into play just as much as when you're considering accommodations. Next slide. religious slurs, negative comments about a person's religion, jokes, comments about religious garments, workplace graffiti, which obviously a swastika could be religious based, and other conduct that's directed towards any religious group. And of course, the so severe or pervasive, and it's perceived by the individual. Remember too that comments posted on social media, and this is the EEOC's guidance, it specifically said comments posted on social media by your employees, where other employees might see them, may be considered harassment, depending on the situation, if they're discussed at work or other employees see them. And historically, I have thought social media comments that an employee makes on their social media accounts that's not particularly directed at an employee, that you could make the argument that that might not be harassment. But the EOC is saying that if other employees can see them, then it could be. So that, I guess that means if you have an employee who is reported someone's making comments on their social media account that's harassing on the basis of religion or any of the other protected statuses, you could ask that employee that's posting the comments if they have other employees who are their friends and who can see their comments. And then you might have to decide whether this is harassment and you need to address it. It's tough because if you take disciplinary action against an employee on the basis of their social media, you could potentially run afoul of the National Labor Relations Act. So tough stuff for employers as always. Next slide. All right, so I'm going to give you some examples, and I want us to all just think, is it harassment, discrimination, or microaggression? You know, a lot of folks talk about microaggressions, and sometimes they are separated from whether or not they could amount to harassment or discrimination. And I would say that it's very likely that some of these microaggressions could lend themselves to harassment or discrimination claims, or at a minimum be added to other things that have happened from the standpoint of accommodation or comments and jokes, in addition to these microaggressions, to solidify or further strengthen their case. So here are some examples. I'm on the GSHRM DEI committee, and these were examples that the committee came up with, and they're great. So you don't look Jewish for Judaism. Assuming someone's greedy or stingy because they're Jewish. Last name is Goldberg, must be Jewish. There's a reason his people own all of New York. Some really good examples that were given during this meeting that I thought could fly under the radar, and maybe would have flown under my radar, is having an important meeting on Rosh Hashanah or Yom Kippur, where attendance is expected. Or this is children, but what about employees who cannot be eligible for perfect attendance because they missed work due to celebrating a religious holiday? Next slide. Islam, someone's a terrorist because of their religion. Comments based on head coverings, religious clothing. Hindus pray to cows. Or reference to caste, and that Hinduism is inherently oppressive. And indigenous, cultural appropriation of indigenous religions, disrespectful comments about indigenous practices like powwows and traditional medicine and more. So you can see these examples that I've just outlined. I think very easily they could at least, if combined with other comments, or if just even whether they're combined with other comments or not, if they're said more than once, could start becoming harassment for the hearer. Next slide. Some things to think about. So many companies have holiday parties. Do we call it a Christmas party or do we call it a holiday party? At our holiday party, are there symbols representing Christianity and not symbols representing other religions? If we have a spring party, do we call it an Easter party rather than a spring party? At these parties, is the only activity an Easter egg hunt or an Easter bunny? Next slide. At a meal, a company meal, a minister is asked to give the invocation, and without saying something like, I recognize there are those of other faiths in attendance today and encourage them to pray as they wish, the minister proceeds to give an invocation and closes with, in Jesus' name we pray. I commit to you that based upon that prior example, if this attendance at this meeting is required, you might be found to be participating in making an employee participate in a religious practice, forcing them to do so. A meal is ordered for celebration at work, and it's the only meat that's ordered is pork. In the lobby of the company, the only symbol put up in the lobby is a Christmas tree. Next slide. So I guess go back. I guess we did pretty good getting through everything. All of these examples I gave came up because they were examples of microaggressions, but the reason I provide them to you is because I do think, and as I was looking at all of them, I do think each of them have a propensity to turn into harassment and or be discrimination. So, you know, sensitivity is important, not just from the standpoint of the DEIB effort, but also for compliance. Never mind that it's also good to be mindful of representation of the minority, and that's going to always impact and improve your business ability because it's going to increase your footprint beyond your own demographic. I think the only other thing I would remind you about, and this is the reason that I covered the predominant religion, is that when there is a predominant religion, just like anything else, people are reluctant to speak up. So assumptions can be made that if no one's talking about it, it's not offensive, or that they are thinking the same way we are. And I think in a situation like this, particularly with religion in this area, it's very important that our employers and our businesses be very cognizant of this and work hard to make sure that they are putting their policies in place, that if you offer, for example, Good Friday as a holiday or Easter Monday, let those be floating, let there be also a floating holiday. If you're closed those days, you're closed, but let there be floating holidays for others to practice their religion. One of the comments or one of the examples that I thought was really important: don't schedule an important meeting that attendance is required on Rosh Hashanah, Yom Kippur, any other religion as it's defined in Title VII, i.e. broadly, any other day. And I know that can be difficult to keep up with, but I think it's important. Those sorts of things will show you are open and mindful and respectful and considerate. And those will be the types of things that if you do end up having some comments and such, those will be great examples for you to use. Otherwise, that this was not the employer, that the employer strives to recognize all walks of life in the religious context as well. And absent those being reported to the employer shouldn't be held vicariously liable, because that's not the employer's position. So I think that's it. We've got 2 Q&As. So Gina asks, when working in an HR at a retirement community as a recruiter, not an employer HR, we hired a CNA of Muslim faith. CNA is certified nursing assistant, who wore a religious covering on her face. Residents complained she was scaring them, and most of them refused care from her. And so she wanted to know if she wasn't sure if the company followed religious accommodation, and she did not have visibility to the outcome as a recruiter. So, you know, no, they cannot reassign her because the residents are scared of her and refuse care from her. Conversely, if she comes to you and she reports, I'm feeling harassed because the residents are saying this, that, and the other, and you ask what she wants, and she says, can I just not serve them anymore? Because it's kind of tough when we're dealing with a skilled nursing facility or a retirement community. Many of those people are ill, and they can't really go anywhere. They're there. And so it's a tough call, but sometimes it's better, as long as it's not going to change any of the terms and conditions of the employees' employment, to keep them out of that. You know, employers are required to keep employees free from being subjected to harassment, and that includes vendors and other third parties. And so here, if there was just an easy enough way to let them work in other areas or skip these residents and nothing else would change, then that might be a good outcome. But for residents to complain that she's scaring them and refuse care for her, I think the answer to the residents would have to be that that's not something that we practice here, and we are receptive to all people who have whatever religion. I think you'd have to kind of put a foot to that. What do you think, Katie?
I agree with that. I agree with that. I think you would have to have that, maybe the conversation with the residents and with her, because to your point, it just might be better that she doesn't serve them and have that conflict. She might want that. So yeah, I agree with that.
Right. And I think I would let her suggest that that's what she would like as the fix. So the next one is, what does a company do that has a Christmas tree decorating contest, which that's great. And, how do we navigate that to include other religions? Well, I think you can say a tree decorating contest for Christmas, Kwanzaa, Yom Kippur, or Native American, like you could list all of them or any religion of your choice. You could say that generally. Katie, what do you think about that?
Yeah, I do feel like that kind of is a tough one, but I like that idea that it's just a tree decorating contest. You can decorate it however you want. It doesn't have to, according to your religion or no religion,
Yeah.
Yeah, I don't know, workout tree or whatever you like to put. I don't know.
Yeah,
Just
I like that.
everything.
I like what you said. It doesn't have to be religious. It can be not religious. It can be whatever you want. I like that. That's a good way for an employer to do that. That'd be fun. That's actually what they do in the Hyatt. I don't know of those of you that are in the upstate area, if you ever go and you look at the Christmas trees or the trees, look, I'm doing it. The trees that they put up in the Hyatt outside, or it within, but sort of in the common area of the facility, and you can walk around and see all kinds of non-religious trees and religious ones, and it's wonderful. So that's a neat idea, whoever's doing that. It looks like we don't have any more questions. Katie, do you have anything else to add?
Nope, I'm good.
All right. Well, the resources, if you can look, the resources, there they are. Tannenbaum Organization, I'll tell you real quickly, is a great organization to help you cover any sort of religious training and recognition of other religions. It's a great resource. I highly recommend you check it out. And I hope everybody has a great holiday. We're thankful for you.
Yes, thanks everyone.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.